So I'm going to begin with yourself, Assistant Deputy Clerk. Ms. Drouin, and I better, if you'd like to answer in French, I can get one of the things from my friend, but I'll ask these, and if you're going to answer in French, please let me know, and I will put on the translation equipment, because unfortunately I am sans bilingual at this time, but I'm working on it.
Thank you.
So, Ms. Drouin, prior to becoming the Deputy Clerk of the Privy Council, you were the Deputy Minister of Justice and the Deputy Attorney General of Canada. Is that correct?
Correct.
And you're a lawyer.
Yes,
And you've been a member of the Quebec Bar since 1992.
that's correct.
And in fact, would you agree you're an award-winning lawyer?
Well, I won the prize, yes,
Yeah.
à l'avocat de l'entreprise de l'année. Yeah.
Right. And so I'm not trying to pump your ego, but in 2009, you were named the Business Legal Advisor of the Year by Le Monde Juridique. Is that correct?
That's correct.
And did I pronounce it correctly?
C'est parfait, oui.
Okay, good. And in 2012, I understand you were awarded the Lawyer Erasmus, which is hyphenated AD.E, by the Quebec Bar, right?
Yeah, that's the Advocatus Emeritus.
Right. And from 2012 to 2016, you were the Deputy Minister of Justice and Deputy Attorney General for the Government of Quebec.
That's right.
And then from 2016 to 2017, you were the Senior Associate Deputy Minister of Justice for the Government of Canada.
That's correct.
And then from 2017 to 2021, you were the Deputy Minister of Justice and Deputy Attorney General of Canada. So for 4 years.
That's correct.
And you can agree with me that that position, the Deputy Minister of Justice and Deputy Attorney General of Canada, is the highest ranking position within the Department of Justice.
Within the Department of Justice, yes.
Right. You answer to the Attorney General of Canada.
I answer or I serve the Attorney General. I also respond to the clerk of the time and to the Prime Minister.
Thank you. And now, while you were in that office, you publicly described your role of the Deputy Minister of Justice and Deputy Attorney General of Canada as follows. And I just want to know if you agree with this. I'd like to begin by describing my due role as the Deputy Minister of Justice and Deputy Attorney General of Canada. I've been in this position since June 2017. In both these roles, I support the Minister of Justice and Attorney General of Canada in fulfilling his or her responsibilities. My duties include giving legal advice and coordinating the legal advice given by the Department of Justice and supporting the development of legislation.
That's true. There's also the part of managing litigations. Yeah.
Right. So in your role as the Deputy Minister of Justice and Deputy Attorney General of Canada, you advised on how to draft legislation for 4 years.
That's correct.
Right. And you know from that former role that when you're drafting definitions in legislation, they're very important.
That's correct.
Okay. And would you agree with the following statement, which, full disclosure, I took from the drafting policy from DOJ? Delimiting definition. A delimiting definition is exhaustive. It is intended to set limits on otherwise ordinary meanings of terms. These definitions normally begin with the word means. Would you agree with that?
I agree with that. I just want to say that there is different drafting procedure, if I may say, or techniques. And for example, when I was head of the Justice Department in Quebec, we have eliminated definition. So just to say that there is different ways of drafting legislations.
Right, but you can agree with me that in legislative drafting, that where there's a definition and that definition states this means, and then is followed by a set of factors or what it includes, you're aware that that is intended to be exhaustive. That's Parliament's intention. You know that.
I know that. If I may, just for the benefit of this commission, we also use a lot in federal legislation the technique of incorporating by reference.
Right.
So we do that a lot. When I was at Justice, we did a report on how many times we use that techniques, and I must say that it's numbers of time. We also know that when we put a definition within a legislation, it has to be read in the context of this legislation. And for the purpose of the legislation we're talking about. So I'm just saying that because meaning can have different meanings at the end, depending in the context in which you are looking at those words.
But and you can agree, that the purpose when you're drafting is to try and carry out the intent of Parliament.
That's the objective of drafting, yes.
Okay. And you know that Section 2 of the CSIS Act, prior to listing what constitutes a threat to the security of Canada, states threats to the security of Canada means, and is then followed by the 4 threats. Fair? You know that.
Yeah.
And you know that under Section 12 of the CSIS Act, that in order for CSIS to open an investigation, CSIS has to conclude reasonable grounds to suspect that a person or group is carrying out activities constituting a threat to the security of Canada as defined in Section 2.
Yeah, that's how the CSIS Act operates, yeah.
All right. And and we talked about this, that the Emergencies Act, it states that threats to the security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Service Act, right? You know that.
That's in the EA, yeah.
And you know that under the doctrine of consistent expression, that where there is an adoption by reference, it's to mean the same thing as the primary legislation. You know that.
I think what I've said is that when we are incorporating by reference, remember, I guess, when you did your bar, we were always talking about mutandis, huh? And that was, the idea was to make sure that we interpret, avec les adaptations nécessaires, the incorporation by reference. Yes. So the idea here, and as I said before, is really to interpret within the context, the purpose, also the decision maker that have to look at similar words.
Okay. And to your knowledge, from what you know, what do you know about Parliament's intention for a threat to the security of Canada in the Emergencies Act to mean something different from a threat to the security of Canada as defined in the CSIS Act?
I guess what I'm saying here is when the legislator adopted the Emergency Act versus when the legislator adopted CSIS Act, it was for different purposes. The purpose of doing an investigation under the CSIS Act is not the same purpose as triggering or invoking the Emergency Act for public order emergency.
And I understand, but you are aware that both the CSIS Act as well as the Emergencies Act were passed within just a few years of one another in the 80s.
Well, I'm pleased to be corrected. Yeah, maybe 4 years. I thought the CSIS was 1984, if I'm not
and you know mistaken. And I take it that you know that one of the reasons that they adopted Section 2 of the CSIS Act, Parliament did, was to limit the executive branch of government from declaring public order emergencies. You're aware of that?
I wouldn't use limit. I think that the Emergency Act was crafted to make sure that there's a lot of safeguards in terms of how we invoke the role of Parliament to confirm or deny the invocation of the Emergency Act, the role of the Joint Committee to supervise the implementation of the measures, and the role of an inquiry like this one.
Okay.
And if I can add, a very important component is making sure that doing so, I mean invoking the Emergency Act, was compliance with the Charter, which was a new instrument following, the previous act.
And in the Emergencies Act, it requires the governor and council to have reasonable grounds, you know this, that there is a public order emergency. Is that right?
Sorry, I missed your question.
So you know that in the Emergencies Act, it actually states that a public order emergency arises from a threat to the security of Canada that is so serious to be a national emergency. You know that.
I agree that.
And so you also know that in order to invoke the act, there has to be reasonable grounds, and that includes a threat to the security of Canada, right?
Agree.
And that threat to the security of Canada is as defined in Section 2 of the CSIS Act, right?
Right.
Okay. So let's talk about that. Can you agree with me that there was not reasonable grounds of a threat to the security of Canada as defined in the CSIS Act and adopted by reference?
I don't agree with that.
Okay, so let's go through those grounds, okay? So
I can help. I know your time is,
yes, and let me...
it's really, what we use is really 2C.
Right, so then we can throw out any other grounds, it's fair to say, other than 2C.
The main, like the real ground was 2C.
All right, so activities within or relating to Canada directed towards or in support of a threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, and ideological objective within Canada or a foreign state. So that is the ground. And that is the single ground, from your understanding, of why the Emergencies Act was invoked.
That's the main ground. Some can say that there's other ground, but that's the main ground we used.
Okay, so let's talk about threats of acts of serious violence and acts of serious violence. Can you summarize for me the threats of acts of serious violence that the invocation was based upon?
I'll do that. I think the clerk will probably add. So if you just look at what you went through this week, who you heard. So we heard from not CSIS, but we've heard from some players, for example, that IMV were present in some of the protests. We've heard also that ex-militaries and ex-law police agents were present. We heard the presence of firearms. We heard also a threat to our economy, threat to and impacts on workers. We just talked about that before. We heard impact on our trade relationship and from GAC. We've heard from CBSA that our port of entry was affected, disrupted, and other port of entries, even after the main war were clear.
Okay.
So we heard from transport also that some rails can be affected by blockades. Right. So we've heard from not only, you're going to hear from CSIS Monday, and You know, when you look at the composition of DMARC, you've heard about that many, many times over
Yes.
the week. Many departments are part of that
Okay.
DM's committee. Why? Because national security is not the result of the assessment of one agency,
Right.
but the result of, as Janice said,
And I
the clerk said
understand.
before, the town
I don't mean to
evaluation.
interrupt. I only have so much time left.
Sorry about that.
Yeah, so I just want to talk to you about first, you mentioned the IMVEs, right?
Yep.
And you can agree with me that an IMVE, it's not just somebody who's radical or whatever. There has to be an element of violence.
So couple of things here. And when you look at C, we want to talk about that. Careful about its threat or serious violence.
Okay.
I guess the or can be an
Right,
and.
it's a threat
also.
of or
Yeah.
and I understand. So these IMVs that the government went on about, first, we've already established that the government wasn't aware of the individuals in Coutts at the time of the invocation that were arrested by the local police department.
I think what we were aware in Coutts was, first of all, they were about to do enforcement, and then I think it was around the 10th or the 11th of February, we heard that they were slowing down enforcement because of the presence of risk of violence and guns. That's the only thing
Right.
we knew at our level, because we're not privy to all the operational risk. So that's what
Right.
we knew at Coutts.
But of course, Commissioner Lucky and her people, they were aware of what was going on. They just couldn't tell you.
Exactly.
Right. And you're now aware, I'm sure you've heard the evidence, that they, in fact, as of the February 9th, had 2 undercover officers embedded with these gentlemen. Are you aware of that?
I was not aware at that time.
Right.
When they do uncover operation, this is the,
Yeah.
we don't know those things.
And these gentlemen that they were going after, they were actually local to the Coutts area. You know that.
I can say I didn't know at that time, no.
Can you agree with me that the facts of that were that that issue was dealt with locally by police under provincial mandate via the agreement that Alberta has with the RCMP?
You mean the contractual policing arrangement?
Correct. It was carried out under that, right?
Yep.
Yeah, so it was provincially dealt with? You agree it was dealt with well?
So I don't know at the end when, they put an end to the blockade, who was doing what.
Okay.
And whether, I'm sure you have heard about that the police of jurisdiction can ask more resources from the center using the section 9.2 of their arrangement. So I don't know.
Okay. And so let's move to Ottawa. Ottawa, IMVs in Ottawa. I understand that CSIS advised that they had no concern with IMVEs in Ottawa. And that's what's in evidence. Is that correct?
Well, this is not how I portrayed that. I understood, and I've heard that some IMVE and subject of interest of CSIS were present. What I understand from their assessment is that they didn't conclude that they need or they have to open new investigations.
Right. And so CSIS did a threat assessment of the convoy, and we saw it yesterday. And I can.
They did, not
gonna,
of the convoy as a whole, again, sorry.
of Ottawa. And let me bring that up. And it is the document ending it's ts.nSC.can.001.0000159_rel_0001. Now, we've all reviewed this. I've put it to folks, and I don't want to have to read it to you. But in this assessment, and also in the statement from Director Vignon, they concluded that there was no CSIS threat, reasonable suspicion of a CSIS threat in downtown Ottawa. Is that fair?
They concluded, looking at who was there, that they didn't have enough to open investigations on specific individuals or groups.
Right. And you know that CSIS only needs to have a suspicion, a reasonable suspicion, to open an investigation.
Well, I think the test is reasonable ground, yep.
Reasonable grounds to suspect. Reasonable grounds to suspect. That's what it says. You know that.
Yep.
And the difference between that and the grounds to invoke a national emergency is that you know under the Emergencies Act, it requires reasonable grounds. You know that.
That a public order emergency
Right.
exists.
And you know, as the former highest ranking lawyer and legal officer within the government of Canada, that reasonable grounds to suspect is a lesser threshold than reasonable grounds or referred to as reasonable and probable grounds. You are aware of that.
Again, I'm sorry, I think we are mixing here. Reasonable ground to suspect what? And this is the purpose of CSIS Act.
Right.
So a movement can represent threat to security to Canada.
Right.
A movement, a situation,
An activity.
an activity.
An activity.
Without having individuals or groups into it that do meet the threshold of CSIS. So I think we need to make the difference between what the movement represented at that time for Canada versus the composition of the movement, whether or not we had individuals that, so there's...
But ma'am, I understand what you're saying, but you're saying that you want to look at the group as a whole. All right. And so I've asked you about Coutts, that was taken care of. I've asked you about Ottawa, all right? You knew that the group, the assessment was that it did not meet that. And now Windsor. Can you agree with me that there was no Section 2 CSIS Act threat with respect to Windsor?
You've mischaracterized the witness's evidence. She didn't agree with you that CSIS had assessed the group, the entire group in Ottawa.
Right. So let me just move over to Windsor. Can you agree with me that you are aware of no Section 2 CSIS Act threat with respect to Windsor?
I think I can go again through everything we have heard from all departments, and that the clerk, with my advice in particular, considered to determine whether or not we believe that the threat, the test under the Emergency Act.
Let me try and rephrase it this way. What evidence and what information of violence at Windsor were you aware of when the act was invoked?
I think it would have been a mistake to do assessment site by site while we were facing a national movement and situation.
Thank you for answering my questions.